So you have to reply today.
Yes. Modified the earlier one and incorporated there in the list of judgments also. They rely upon.
Yes, one question which arose was this regarding marking of exhibits. Have you clarified in your written notes of arguments regarding?
Yes, I have mentioned the exhibits also. I've mentioned the marking.
Whether signature was exhibited or whether the document was exhibited. Have you
But
clarified
that-
in your written note?
But that I did not, because on the last occasion, I had mentioned before this honorable court that the signatures in the document, particularly my lord, takes up page number 88, my lord,
Of the paper.
of the paper book. My lord, kindly has a look at the documents that have been marked as it. And the signatures that have been marked as exhibit. Would take up the exhibited documents. My lord, exhibit 1 is the arrest Khatiyar, 155. This will be actually 155 by 264. This is only one Khatiyar, not two Khatiyars. Exhibit 2 is the Khatiyar being number 319. Exhibit 3 is the registered sale deed number 2649. This is the deed which was executed by the Taslimuddin Mia who prior to his death. This is the only deed which has been executed by Taslimuddin Mia directly in favor of the plaintiff. And then my lord comes exhibit 3 by 1, the signature of the deed writer on the same exhibit 3. Then exhibit 4. Then exhibit 4 is the signature of Abdullah Jizmi. My lord, is in my opinion ought to have been exhibit 4 by 1. Mostly because the learned trial court, while exhibiting the document concerned, initially marked the same. Kindly takes up the next page, page number 89.
Actually, the document is marked exhibit for examining the maker of the document.
Maker of the deed.
So if the deed writer is the maker of the document.
Yes, if his signature goes in as exhibit X by 1, say for instance, here it is marked as exhibit 3 by 1.
For example, in case of will,
yes,
the execution of the witness's signature.
yes,
The signatures are identified by the witnesses.
yes. The will is,
But the will,
yes,
will is also identified, but
will is
sometimes
also identified
if it is drafted by the
by the
advocate,
same
then
person.
it should be identified by the advocate. It
Generally-
is prepared by you.
Yes, generally the signatures are marked as say for instance A by 1 or A by 2 or A
And
by
the
3.
will is also
If the
marked
will is
exhibit.
marked as A.
There is no other because maker is not available.
Yes, that
Either
is
the one who has drafted, that is the advocate,
that.
or the witness.
Yes. So here my lord would find
Whether
that-
the deed writer is the maker of the document.
Yes.
That is the question.
that is the question. My lord, here my lord would find the deed number 1006 in respect of which the my learned friend had raised
That is exhibit number?
My lord takes up page number.
Oh, exhibit 4.
Yes, my lord takes up first 89, page number 89. Exhibit X by 1. 89, my lord.
Yes.
Exhibit X by 1 for identification.
Yes, that is page 88. It is marked exhibit.
And it is page 88, it is marked exhibit because after the signature has been exhibited, the signature ought to have been marked. So signature has been marked. If the signature has been marked, the deed is automatically executed because exhibited because it is an original deed. The records need not be produced from the district registrar's office or from the registration office, as was held by the learned first appellate court, because this is not a certified copy that the volumes need to be produced to exhibit the document. These are the original, and these deeds have been written by the person whose signature has already been exhibited. So accordingly, in my most humble submission, the concerned documents, though it has been marked as X by 1 for identification, is automatically exhibited upon the signature of the deed writer being marked as exhibit 4 in the page number 88. Exhibit 4, since the signature of the deed writer is marked as exhibit 4, the deed writer identifies the signatures of the person who executed the deed, and his signature has been marked as exhibit 4. Automatically, this exhibit, it ought to have been marked as exhibit 4 by 1, which is on the part of the learned trial court might have, but this is already on record. Similarly, it is the similar case with exhibit 5 also, my lord. The next deed, that is the deed number 1445. Here the signature has been exhibited as exhibit 5. The same deed, which was initially filed by the PW1, initially was marked as exhibit X by 2 for identification.
1006 ought to have been marked exhibit 4/1.
Yes. Exhibit 4/1, and there and 100, this is 1445, the next one. This ought to have been subsequently marked as exhibit 5/1.
Whatever is there, it is marked.
No, this is already admitted.
Whatever is.
This is already admitted from the record. It is an original document in respect of which no objection has been put forth by the defendants at the time of exhibition of the said documents, when the documents were marked as exhibits. No objections were raised, neither at the appellate stage, first appellate stage, nor at the trial stage. Similarly, my lord would find the remaining of the deeds.
Yes.
Those are also marked in a similar manner. All the signatures coming from exhibit 5, continuing from exhibit 5, exhibit 6, exhibit 7, exhibit 8, continuing up to exhibit 14. My lord. The next page. Continuing up to exhibit 14. These are all marked. Now, these are all the signatures on the respective deeds concerned. Now, if the signatures have been identified, the person whose signature is the deed writer, if that has been marked as exhibit, obviously the deed itself, generally, since it's an original deed, maybe the presumption is in favor of the plaintiffs that the deeds are been marked as exhibits as well, the concerned original registered deeds. So, this submission on the part of my learned senior colleague that the deeds have not been marked as exhibits, and so the plaintiff's case fails is not sustainable. Now, as regards the other contentions raised by my learned senior friend here, is that my lord would take up my list of my brief notes of argument, wherein I have specifically taken this point that the date of death. My lord takes up my brief notes of argument.
Yes.
Yes.
You can watch it.
My lord, no, that is the earlier one. I have filed the.
Oh, there is a comprehensive one. That is the next.
This is the comprehensive one, including the.
So ultimately, you are relying upon this one, this comprehensive.
Comprehensive one. My lord, it contains the judgments also.
So the judgment you have given another sheet.
Yes, that
Judgment
is
compilation.
attached together.
Yes.
Yes.
No, this one, this two.
Yes, two together.
Not this earlier one.
Not the earlier one.
This two.
These two. My lord, to return back the earlier one so that confusion doesn't arise. Ageta আমাকে দিয়ে দিন। Now, my lord, here I have specifically harped on the issue number 7, as was decided by the learned trial court. My lord, the issue number 7 is one wherein it has been particularly dealt with regarding the date of death of the person, the predecessor in interest of the plaintiffs. My lord, that issue that my lord would find in the paper book as issue number 7 in the judgment, my lord would find there under page 90. Well, there's a detailed discussion on the issue.
Page 90.
90, issue number 7.
Okay. Number.
There's a detailed discussion on the issue.
By the trial court.
Yes, by the trial court.
Yes.
As to what is the date of death of the Said Taslimuddin.
This is your point number 7.
Yes.
Yes.
Point number. Point number 11, my lord, of my little notes of argument. Paragraph 11 and 12. 11 and 12 relate to the date of death. Paragraph number 11 and 12 of my written notes of performance. So
Yeah.
here, the discussion that was taken up by the learned trial court is regards a particular period. My lord, it has not been opposed by learned friend for the opposite party that prior to 1st of July 1980, any person whose death occurs prior thereto, even if he is a Muslim, would be governed by the Dayavaga school of law. That is not disputed. That is not contradicted by my learned for the opposite party. So it is settled that prior to 1st of July 1980, when the West Bengal Assimilation of Kuch Bihar Assimilation of State Laws Act came into force and the notification act thereof applying all the laws prevalent in the state in the state of West Bengal came into force in the state of Kuch Bihar, erstwhile princely state of Kuch Bihar, now the district of Kuch Bihar. That is with effect from 1st of July 1980. That is not disputed.
So anyway, you have explained
Yes.
how you have countered
Now-
the argument of the
Yes.
defendant
Yes.
respondent.
Yes, now the thing remains that whether this person concerned died before that particular date or he died after that particular date. My
Now,
submission
it is
in respect
The
hereof,
bone of content, your bone of
Yes.
contention was that
he died
Sir,
prior
that
to
is
that.
held in 1006 where it is mentioned late.
He has himself
So,
executed it
so this is the document, no, but deed by this, deed
by the son.
by the son.
By the son. It was executed sometime in the year 1979.
Okay.
Since it was executed sometime.
And there is no scope to
There is
examine
no
that son.
scope
No, no.
for-
There is no scope to examine the son, but the deed writer.
Yes. Now the deed writer has.
Deed writer PW5
Has
in his chief has stated that
he executed the deed.
he has executed the deed and.
He has written the deed. Basically,
Yes.
he is the writer of the deed.
No.
That is-
That is why the deed writer was brought.
Yes.
Yes, so
So-
PW5,
Yes.
PW5 said that the deed was prepared by him,
By him.
definitely under the instruction of the
Definitely under
parties.
and he is.
Now the question is, in his chief, he has stated that Taslimuddin died in 1981. In his cross-examination, he has stated in
No.
1985.
No, in his chief, he is stating that Taslimuddin died prior to 1980. Prior to 1980, that is sometime because he has drafted the deeds. The last deed of Taslimuddin, which was drafted by him, was of the year 1975. And thereafter, the first deed which was drafted by him, which was executed by the son of Taslimuddin, was of the year 1979. So in between these two, this 1975 and 1978.
The 1006 of 1978,
1006 of 1978, this is the deed that was drafted.
by which this purchaser plaintiff came into
Yes,
picture.
yes, and prior thereto, I have to take note of that deed number 2649. This was in the year 1976 when he was alive. Taslimuddin himself executed that deed.
That is 1975 and 76.
76, he was alive. That
Yes.
is on this very date. That
And
is
75 also another deed was executed.
25th May of 1976, this Taslimuddin himself executed that deed. So he was very much alive.
1975,
1976. 25th May 1976, he was very much alive.
Right.
That deed was written by the PW5, who was the deed writer. Now, the deed writer happens also to be a relative of the said Taslimuddin, because Taslimuddin is his Pishamoshai, which he has stated in his cross-examination.
The thing is this held deed 1006 of 1978, that is also by PW5. It was prepared.
Yes, it was also prepared by PW5. But
This
that
deed
was-
was also prepared by this
Yes.
PW5.
this
And
was
this
also
one is
prepared
also
by
by
PW5.
PW5.
It was executed by the son of the Taslimuddin. So,
So this
1006 was executed by the son.
but prepared by the same
Prepared by
deed
the
writer.
same deed writer. Now that means while he is writing, when he is executing, when he is writing the deed for the son and writing after the name of the
He's a
son.
professional deed writer.
Yes, let Taslimuddin Mia.
No, you see, the cross-examination took place on the very same date or some other date.
It took place on continuously on repeated.
No, just after the chief was over,
Yes,
the cross-examination, okay.
my lord.
Because you see, in chief, it is not stated orally
Yes.
that he died on so and so date or something like that. Okay.
Yes.
Whatever is there in the chief, that will go.
Yes,
But questions are put in cross-examination
yes, my lord.
regarding the date of death.
Yes.
So was that cross-examination on the self-same day or on some other day?
My lord takes up that.
No, that is just a question of fact, you see.
But the cross-examination, as I find from the record, at page 650 of the paper, my lord.
Although you see, this is a second appeal is a purely a question of law.
Yes,
Only this, I think that the learned appellate court
yes.
also did not set aside on the version of this PW5.
No, not on the version.
Not on the version of
not on
PW.
the version of the PW5, but he somewhat relied upon the version of the PW5, relying that he has
That is what, to some extent by PW5
yes,
and the technicalities of that record of rights.
yes.
And yes, that's why I'm asking that whether that is the ground to
Yes,
disagree that PW5 cross-examination.
Yes,
And then these technicalities of that record, that plaintiff number 9 is not mentioned.
yes.
And the third is this record of rights say something.
Did not
Position.
enter into the merits of the case. The
Record
first
of-
appellate court did not even enter.
No, record of rights regarding possession.
Yes.
No, if you get it,
Except that. Apart from that, nothing.
no, possession was held in favor of your learned friend.
Yes, but he has not delved into he has not given any reasons for coming to the same judgment.
No, for possession, you see, simply cited that record of rights.
He has stated that the record of rights is substantiates that they are in possession.
Document
But
of
he has
possession.
failed to notice that that particular document was not even executed by, not even exhibited by the defendants. It was exhibited by the plaintiffs to prove the fact that in their particular document, the date of death of the Taslimuddin Mia was written as 1975, which cannot be the case because in 1976 in the month of May 1976, Taslimuddin Mia himself executes a deed. So he was well alive in
Actually,
1976.
as far as possession is concerned, and under the specific relief act,
Yes,
the court came to a finding that the possession from the record of rights goes to show that the defendant was in possession.
that is something which was
That is what that has
by the
gone,
learned first appellate.
that has gone in favor of your learned friend.
I object to that observation made by the learned first appellate court by reason of the fact that a revenue record is this Khatiyan which has been relied upon is only a revenue record. It cannot be considered as a
Okay, and under what status this
cannot
person
be
was in
considered as
possession?
it cannot be considered as a
No,
final-
the question of the possession
Yes.
was under what capacity?
Yes. Under
Right.
what capacity?
Very well, record of rights shows his name,
Yes.
but under what capacity possession? Suppose
She does not,
inherited, okay.
no, she does not inherit.
No, very
She
well.
cannot-
Very well. In before
Now-
PLRO, some declaration may be given.
Yes.
You see, everybody is not acquainted with the Mohammedan law.
Yes.
So they may go and declare that I am the heir, please record my name.
Yes.
That can be done any of the years.
Any
can
of
go
the years.
By declaration that I am the son, daughter.
Yes.
Very well, the BLRO will record.
Yes.
Now then the question comes is, by virtue of inheritance, that means that is not a position, that is a right.
Yes. That
That is
cannot
not
be
a
given.
question of position. It is a matter of right.
How can it be?
Yes, position means it's on oral evidence. There was oral evidence.
That was
Yes.
already rebutted.
Yes, is not a question of position. You see, matter of inheritance. You see, even if you stay in America also, if you inherit to a property in Kuch Bihar,
Yes.
definitely nobody can deprive. Your name has to be recorded.
Yes.
My house is there. My deposition where I say my house is there for 27 years and cultivating there.
By virtue of inheritance, it has to be recorded.
Now, if my lord, my learned friend goes into that, I would be going back to the unamended, this section 23 of the Succession Act concern, which was at that point of time, in case of homestead land, female heirs had no inheritance, had no rights whatsoever.
Because you see, that is one point in your favor, that possession. If you are in possession, you cannot, that injunction cannot be granted against you. That is one thing.
The learned
Assuming,
first appellate court, I'm sorry to interrupt, madam. Learned first appellate court has granted partial, basically he has reversed the decision passed by the learned trial court. And in doing so, what he has done, he's refused he has not stated that the defendant is entitled.
now only let us come to the findings of the trial court regarding possession
Yes.
and the appellate court regarding possession.
Yes.
Because you see, unless you are in possession, your
Definitely.
possession cannot be protected
Yes.
by injunction.
Yes. Now I have produced the deeds and I have stated in my claim, it is my categorical submission. in
Okay,
my
that
claim.
is issue number now regarding I think the learned trial court did not go into the issue of possession,
Learned trial court already
Yes, where is
examined the
that?
position, my lord.
issue of possession.
My lord, kindly, my lord,
Issue seven.
issue has been taken up. My lord takes up the issue, my lord. That is at page 80, 87 and 87. 87 and 80, continuing up to 80.
Fine.
My lord,
Fine, big deal.
Whether, yes, yes,
Fine.
65 is, 34 is maintainable or not,
that is section 30.
yes. So, to see, want the protection with regard to your possession, you have to show prima facie that, yes, you are in possession, that much.
And
Maybe entitled to a declaration that you are the owner.
Possession of the, was not the. So you should try with, only right.
But my prayer-
That ought to have been framed because declaration and by permanent injunction, so the moment you
Now, my lord,
Possession of.
was not framed.
my lord takes up my prayers in the plate. If my prayers in the plate are looked into, my
That
lord,
is
that
page,
page, my lord, would find it at page number 9 of the paper book. My lord, my specific prayer was declaration that the plaintiffs have right, title, interest and possession in the suit.
page nine,
Page number 9
yes,
of the paper book.
yes. Right title, interest, very well, and possession.
And possession in the suit.
Oh, that means you wanted a declaration of a right title and interest,
And possession
and
in the
possession.
suit. And then a consequential relief of
a
permanent
permanent injunction.
Yes.
So if you have a declaration of possession, you have a right to possess,
yes,
then definitely
yes.
you
So,
have- they will be
my-
injuncted,
yes, my lord takes up paragraph number 16 of my.
and injunction will be granted if you are in possession.
Yes, definitely. It was ruled by the learned trial court that I am found in to be in possession. The document, that is the Khatiyar number 319, was not considered, was rejected by the learned trial court. And the reasons for its rejection have been well explained in its judgment. My lord takes up paragraph number 16 of, that is the page number 8, my lord, the earlier page. Earlier page, my lord, wherein in paragraph number 16, I am specifically pleaded that all the plaintiffs purchase the respective land from the legal heirs of the deceased, Taslimuddin Mia, and possessing their respective portion, which is described in Schedule A of the plate. Defendants and their name, a single transaction, single act invaded the rights of the plaintiff jointly.
No, if you see, if Taslimuddin
Madam.
Mia has, okay, Taslimuddin Mia has conveyed his absolute right with
Yes.
regard to land,
Yes.
then in that question, whether any dispute comes regarding inheritance.
But Taslimuddin Mia did not himself convey absolute rights.
No,
How
here,
the-
what does it? Oh, from the legal heirs, right?
Legal heir.
Legal heirs.
Legal heirs conveyed the remaining part of the land. Of
Whatever was in their possession, they
they
have.
conveyed. Initially, Taslimuddin conveyed by virtue of one single deed. Thereafter, several deeds executed in favor of the plaintiffs by the legal heirs, that is the three sons.
And the date of preparation of record of rights and the date of purchase.
Well, the date of preparation of record
Record of
of rights
rights.
was subsequent, definitely date of purchase was there.
Yes, the date of purchase was a particular date.
Yes,
And the record of rights on
Doesn't-
which the defendant relied, is it subsequent?
no, my lord, it doesn't reveal as such.
Because you see, you know the date of purchase
Yes, my lord.
and the record of rights by which, that is not, that is not clear
That is not.
when the name was incorporated.
That was already answered. Okay.
Exhibit 2 or Exhibit B? Oh, from your side?
Yes.
Yes, Exhibit 2.
They are
Yes.
not existing.
Yes, yes, your side.
Yes. Here, this is the name of dog. So, here, this is the name of the school. So,
That means in 1975, it is recorded before the authority that he died in 1975.
He has inserted.
That means it is recorded by mistake.
It is recorded by.
I said from 75 or maybe by mistake.
Recorded by the London Transport.
Some typographical mistake, handwritten.
Handwritten. And yeah, it is written here and stop. What is stop? What is stop? What is stop?
Yeah, that means who are the Warish?
That is why what is stop cannot be, because she cannot be legal.
No. Anyway, you see, BLRO is not the authority to decide who is entitled to succeed.
Somebody approached.
Because he will follow the Hindu law of succession. He will not follow that. Because you see, sometimes in the possession record, sometimes it is stated as a permissive possession or whatever it is. Anumoti dong or jabot dong, whatever it is. So here it is recorded that the original owner died, Mrito, and the Warish, these are the Warish gone.
The dependent number one daughter. But this is contradictory to us.
No, you see, if something is submitted before PLRO, that we are the legal heirs and stated or no.
I am not on that point, but I am on that point.
No, very well. It is PLR, it is recorded before PLRO that these are the legal heirs. Nothing unusual.
Nothing unusual, and this document cannot be considered as a
Ownership right.
a
Legal right.
Yes.
Now whether by recording the name of the heirs,
Yes.
will go to show the possession or not.
Definitely not, because it is the Khatiyan itself in the name of Taslimuddin.
That
It
means
is
after
written
his death, it will
Within
flow to
brackets
his,
written Mito.
yes, from there he will flow to.
If it will flow. Now that I have already discussed in the judgment that I have.
You see, PLRO has recorded on the conception what is represented to
Yes.
him that we are the legal heirs.
Ignoring the rule that has been framed by this.
Anyway, that is not challenged. That record of right is not challenged.
Yeah, 1981 Cal 48.
Whatever PLRO has, whatever the heirs have submitted, PLRO has recorded.
PLRO has recorded.
And subsequently, that purchase took place, but the purchaser did not incorporate his name in the record of right.
And the date, as my lord was inquiring about, I find multiple dates. My learned friend would agree. There is a date in the year 1978. There is a date in the year 1998.
But it is stated Mrito 1975.
It is written 1975. Mrito in 1975.
And these are the Warish one.
Now, only one name is mentioned. Original defendant number, name, daughter.
He stated as Warish.
Is Warishan?
Only daughters are mentioned. None, no son.
No, there is no
See,
other
plot of land, if it is inherited, what is represented before the authority that by affidavit? No, whatever is there, okay, let us go what is there in the document.
Yes.
In the record, it is dated Mrito in 1975, very well, that may be disputed. The other thing is, with regard to what is only
the name of the defendant number one. Only the name of the defendant number one. Total amount of land in the Khatiyan of this Taslimuddin Mia was 8.84. Out of the 8.84, even if it is taken in,
that means you see,
cannot be for
it
50%.
happen that by virtue of the succession, there are other areas, so I am entitled to only this much.
No, he is not even entitled to the amount that has been mentioned.
That is not known to the BLRO.
That is not known to the BLR.
How can the BLRO know that?
That is the thing. Might be so that she represented herself as a sole legal heir.
That may not be, because
Suppressing the
that 4% is there, 4 point something, otherwise we will say that entire record will be in my name.
Yes, my lord, the natural presumption, if I may say so, that can be drawn from this
See,
document. That
this
has
is
been-
the, you see, what is against you, you should also meet that.
Obviously, my lord,
That
I-
possession and the document. So I thought that is the document with regard to possession.
yes, my
So,
lord.
but it is the document regard to inheritance of a particular plot of land.
Inheritance. Now, that particular document which purportedly shows the inheritance
Inheritance of the ownership of the land.
of the defendant number one,
Yes,
that is directly hit by the judgment passed by this honorable court in the case of Anisur Rahman and Jalilur Rahman, wherein the honorable court has specifically laid down that in respect of the female, in respect of the Mohammedan subjects of the state of Kuch Bihar, the female heirs have a limited interest since they are governed by the Dayavaga school of
anyway,
Hindu.
that you have discussed in your
Yes.
argument.
So,
You have annexed the judgment also.
yes, I have annexed the judgment also. So, by virtue of that judgment, the female heirs would not be entitled to inherit the property so as to,
That is a question of law.
so as
Okay?
to transfer it to
And
third
this is
party.
a question of record, what is recorded as the owner.
So that recording goes directly against the rule.
Yes.
That cannot be
yes,
the
yes.
case. It contradicts
Because
the
the-
very law itself on the law, based on the inheritance and the succession rights.
Yes, because the appellate court had held that she is in possession on the basis of that
Yes, that,
record of rights.
yes, but the appellate court lost sight of the fact while doing so that the law stipulates otherwise. That she cannot be an heir. She cannot be an heir in view of the specific.
And
peculiar
here
situation.
recording of the name will not go to show that a person is. the owner.
Yes, she is not, that recording is not going to go in her favor. And more so, in respect of the Dayavaga law, which was applicable in the state of Kuch Bihar at that point of time, prior to the this codification of the Hindu laws, the females had a limited interest only to the extent if they are unmarried, they had an interest to reside in the property concerned. Other than residence, they did not have any right either to gift, transfer,
Under the
sale,
Dayavaga law.
yes,
Under
or
full Dayavaga.
under the Dayavaga law. Co-personality interest they did not have. They did not even have that right to even transfer that property to any third person. So even the heirs, succeeding heirs of that female are not entitled, that is the present respondents in this instant appeal, as well as the defendant numbers 2 and 3 in the suit. They are not entitled because they are the sons of the said Majlis. Now, my lord, as regards the decision that has been arrived at by the learned trial court, my lord would take up particularly page number 117, if I may refer, 117, wherein the issue as regards, this is the order passed by the learned first appellate court also, wherein the decision of the decision of the trial court was quoted herein. My lord would find there that as regards the possession, this is,
Yes, which page?
my lord, page number 117. 117 of the, this is the appellate court judgment, first appellate court.
Yes.
My lord, towards the last part, towards the end of the paragraph, decision with reasons. Decision with reasons towards the last part. If I may read from the relevant paragraph. My lord, as Taslimuddin was guided by Dayavaga law, so his 3 sons inherited all the properties left by their father, Taslimuddin Mian, and possessed the same under personal cultivation. Defendant number 1 got married during the lifetime of Taslimuddin, and after marriage started residing with her husband along with her 2 sons, that is the defendant numbers 2 and 3. So it is the defendant number 1 who claims by virtue of the Khatiyan 319 already a married daughter at the time of during the lifetime of the
And
Taslimuddin.
is what agriculture or homestead?
Agriculture, personal cultivation.
Agricultural land.
Yes, and the defendants never owned and possessed any portion of the suit land at any point of time, nor they have any possession of any portion of the suit land.
That means
Till
that
date.
land is for purpose of cultivation, not for residing purpose.
There is no
Cultivation
no,
and-
it
and
is
tryout.
entire land, yes, right. Entire land was for cultivation. Entire land was used for cultivation. So now, this is the,
So the stand would have been
yes,
own the land, possess the land and cultivated the land.
yes.
Either
Now,
through Borgadar or personally.
personally, now, my lord, what is stated herein It is already part of the judgment of the first appellate court. Therein it has been clearly stated that defendants never owned and possessed any portion of the suit land at any point of time.
Because that page 119, right, is the second paragraph by 11 first appellate court discussion.
Yes, I'm coming to it.
Thereafter, comes.
Now, if that is so the case, the defendants have not in their evidence neither produced any document. They have not exhibited any document. There is no exhibit on the part of them. And also in their examination and cross-examination, they have not been able to come up with anything except stating that yes, this defendant number 1 is the daughter of the Sayyid Taslimuddin Mia, and the defendant number 1, since the Sayyid Taslimuddin Mia, they contradicted the date of death to be beyond 1980 and stated that hence the Muslim personal law would be applicable to her and she would be entitled to issue. That is the only submission made on that point by the defendants concerned. They have never, in their cross-examination, they have never been able to come up with any document or with any evidence as regards their position that they are carrying on cultivation. They are
regarding death, the flow of title and ownership.
Yes.
By virtue of inheritance, that is death.
That is
the fact.
That
and the second is by possession.
By possession. Neither by possession nor by way of inheritance. They could
If
not.
the death is proved, then law will apply. Law with regard to inheritance.
Yes. They cannot.
The second is possession. If you are entitled to a particular relief,
cannot approbate and reprobate at the same time. So if he says, if she says that yes, he was the person died, if it is proved that it is he died before 1980, that is the 1st of July 1980, then she is not entitled to any share. Now, if she is not entitled to any share, she cannot claim any possession in the suit lands concerned. So that was the submission particularly made on my behalf. And another point that I would like to raise for my lord is that the issue regarding Section 34, which has been on the last occasion, it was added by this honorable court. The issue regarding Section 34, I have specifically pointed out the issue regarding the applicability of Section 34. I have relied on 3 judgments specifically of various high courts as well as the honorable Supreme Court to drive home my point. In the first judgment which I have referred to, that is in the matter of Jian Kaur versus Rajveer Singh. Takes up my list of judgments reported in 2001, volume 4, SCC. Here in paragraphs particularly 8, 9, 10, 11, 12 and 13, the Honorable Supreme Court specifically has held that a title suit where consequential relief of permanent injunction was prayed, finding of the High Court that the suit is merely for declaration and not maintainable under Section 34.
Para 8.
Beginning from para 8, 9, 10, 11, 12, 13.
Yes, the Honorable High Court, while entertaining the section.
Yes. The Honorable High Court was of the view that the suit is merely for declaration and not maintainable, being hid by Section 34.
Yes.
However, the Honorable Supreme Court was of the view, no, since there is a consequential relief of injunction prayed, it cannot be said that the suit is merely a declaration simpliciter. So it is not hid by Section 34. When a consequential relief is prayed for in a suit, along with the principal relief, it cannot be said to be hid by Section 34 of the specific law. Second judgment which I have relied on, my lord, that is that one in Jersey law. That is the one in Gyarsilal and versus Gopal and others, reported in 2002 Supreme. This is the Rajasthan High Court. But in the Rajasthan High Court has specifically said that when plaintiff's title to the property is in dispute. Now, what's my case here? My case here is that my title to the property is in dispute. I am in possession of the property. My cloud has been cast upon my title. Hence, the defendants are trying to enter into my suit property, try to encroach the same. Hence, I have come before the learned court, learned trial court with a suit claiming declaration of my right title interest in possession in the suit land and a consequential relief of permanent injunction restraining the defendant from entering into suit and disturbing the prosecution. So, if I am in possession, I need not claim any other relief such as recovery of possession. In the
injunction.
Yes, I can claim only the consequential relief of injunction along with the declaration of title, of my right title interest in possession, which I have done. My prayer shows so. So, when the plaintiff's title to the property is in dispute, there is a threat of dispossession. The plaintiff should sue for declaration of title and consequential relief of injunctions, which I have. The appellant relies upon paragraph 3 and 9 of the same chapter. 3 and 9. Then, my lord, comes the next judgment. This is also the Honorable Supreme Court. This is directly taken from the Supreme Court website. The report is in civil appeal number 3253 of 2025. Is a currently
Reported judgment.
my lord, this is
Or this Indian Kanun.
directly no. This is directly from the Supreme Court website.
Right.
So, in the matter of Ranjit alias Bhayu Mohite versus Nandita Singh and other, I just placed this judgment just for the purpose of stating that what's the relief that I should be claiming in my claim depending on the amendments made in the. Herein, the case was that it was held by the Supreme Court that when the plaintiff is in possession of the bulk of the suit property and only a minor portion is out of his immediate control, therein the situation was such. A simple omission to claim possession from the
Just
start.
which paragraph?
Paragraph speaking. A simple
Yes.
yes. Where the plaintiff is in possession of the bulk of the suit property and only a minor portion is out of his immediate control, a simple omission to claim possession from the start does not in itself mandate outright rejection of the entire claim. Here, what had happened? An Order 7 Rule 11 application was filed. Thereafter, the trial court dismissed, and Honorable High Court allowed the reverse the order and said yes, it is maintainable. Order 7 Rule 11 was granted, challenging that the appellants were before. Instead, as long as the plaintiff pleads possession of most of the property and seeks declaratory relief along with an injunction to protect that possession, the proviso to section 34 is not violated and the plaintiff therefore not barred by section. Here the Honorable Supreme Court also ruled that when I have declared in my claim, it is my plaintiff case that I am in possession of the property, but my possession is being threatened by the opposite parties. My right title interest cloud is being cast upon by the opposite parties. My relief is to claim a suit for declaration of my right title interest in the property, as well as a consequential relief of permanent injunction restraining the defendant from entering into the property and from disturbing my peaceful possession, which I have done. So it cannot be said that my suit is barred by section 34 just because I have not claimed recovery of possession. My case is, I am in possession. I am not entitled to claim recovery of possession. Had I not been in possession, had it been the admitted fact, had the trial court come to the conclusion that yes, the plaintiff is not found to be in possession, then section 34 would have happened. Next, my lord, I written it because I forgot to mention. So this is the judgment which I was earlier referring to. That is the judgment of Manisur Rahman regarding the applicability of the Mohammedan Hindu
Have you
Dharma.
annexed imposed here?
Yes. My lord. Yeah, 1921, Calcutta Fund.
Yes, you have relied on the earlier occasion.
Yes. So I do not want to go into that. Regarding section 34, this is not the case law. This is only the case law as regards the applicability of the Theravada school of Hindu law upon the defendant's concern.
Regarding section 34, this Supreme Court decision.
Supreme Court decision. Yes. Supreme Court decision and one Rajasthan evidence. So my submission respectfully would be that the learned trial court in its apt wisdom passed the decree in favor of the plaintiffs. The learned trial court examined all the issues in detail, particularly the main issues as regards the death of the predecessor interest of the plaintiffs or the father of the defendant number 1, and particularly the issue as regards whether by virtue of the Khatiyan, alleged Khatiyan in the name of the defendant number 1, any right would accrue to him. That was also discussed. Both the issues were decided in favor of the plaintiffs, as well as all the other issues were decided also in favor of the plaintiffs. The learned trial court then rightly proceeded to decree the suit in favor of the plaintiffs, though only a part of the scheduled property, because some of the defendants did not subsequently participate in the suit. So, learned first appellate court, while taking up the appeal from the decision of the learned trial court, grossly erred in its wisdom while setting aside the said judgment, relying on two aspects, just harping on one typographical error in the said plaint and another, that is the plaintiff number 9 and 10. There was no plaintiff number 9 and 10 in the plaint. It would be evident from the deeds itself as to whom the deeds in whose favor it has been executed, from wherein it could be seen that it has been executed in favor of the plaintiff numbers 6 and 7, not the plaintiff numbers 9 and 10 that could have been easily gone through by the learned first appellate court. Learned first appellate court did not take any. Now, as regards the issue regarding section 34, that is the second point, second contention on which the suit was, the decision of the learned trial court was reversed. Section 34, in my case, as I rightly, as I have already laid down, I discussed before your lordship, is not applicable to my case. Herein, I have prayed for all the reasons which I am entitled. I cannot be said to have accrued a right to claim recovery of possession, because the recovery of possession would be such which would go against my pleadings made in that way. I have specifically stated in my claim that I am already in possession. So, hence, if I am already in possession, if that possession is not rebutted by the defendant by adducing sufficient evidence, then my position stands that I am already in possession. So it cannot be said that my suit is barred by section 34 because the additional relief of recovery of possession was not claimed by me. My suit was for declaration of right title interest in possession and with a consequential relief of intention. So in my most humble submission, the judgment which has been passed by the learned first appellate court is highly erroneous, ought to be set aside. The judgment of the learned passed by the learned trial court ought to be upheld by this honorable court in this instance.
That's all.
Yes.
Yes, hearing concluded, record an order. Have you submitted your written notes? Yes. Learned advocates. Learned advocates for the parties have concluded their submissions and have filed the written notes of arguments. Let the same be kept with the record. Hearing is concluded. CAB. এই রিটেন নোটস গুলোকে ঠিক করে ইয়ে করে দিলে এই রিটেন নোটস বা আমাদের রিটেন করতে দিয়েছে এগুলো সিএবি
Grateful.
সিএবি ইমপ্লিমেন্টেশন করে এটা থ্যাংক ইউ yes, thank you. I also thank you for the cooperation extended and wish you a happy holiday.
So it was a pleasure doing this hearing.
Right.
Yes.
We mentioned a decade after the Yes, item 1, who is for the appellant? Yes. So, who is for the respondent? Have you served? Well, section 5 is to be taken up. You have served the claimants. You have filed, you have deposited the statutory amount. Yes, record an order. What is your section 5? Can 1, can 2 does in it? Can 2 ache ke nahi? Okay, can 1 fine. How many days delay? No. Yes? Yes, learned advocate for the appellant insurance company is present. None appears for the respondents in spite of service. Let the affidavit of service file be kept with the record. The application for condonation of delay being can 1 of 2025 is taken up for consideration. The appellant in the state application has prayed for condonation of 3 days delay. Stop. Upon perusing the grounds furnished, this petition is allowed and the delay is condoned. Can 1 of 2025 stands dismissed. Stop. But can 2 of 2000, this application for stay is taken up for consideration. Stop. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated Just a minute. Judgment. Twentieth November 2024, passed by learned additional district, passed by the learned district judge, Kuch Bihar, in MSC case number 42 of 2022 for a period of 5 weeks. The appellant insurance company is directed to pay the awarded sum along with interest as directed by the learned trial court within 5 weeks from date. In the event such deposit is made within 5 weeks, the ad interim order of stay shall continue till disposal of the application for stay. Yes, liberty to mention.
Same matter is there.
Just let me see. The court will rise at 3:30 today.
Yeah, but
Anyway, let me just wait for 5 minutes. Remind me at 3:15 if it is not taken up. Is it a section 5 application? Yes, it was inadvertently mentioned before the division bench.
get submitted that there is a delay of about 49 days. However, the endorsement of the stamp paper indicating that there is no delay. Accordingly, my lord, scan one.
Let me see. What is scan 2 for?
Statement. Can we state?
Oh, that cannot be granted by this court. After admission, it has to be passed by the
Yes,
division
yes,
bench.
that
Yes,
should-
can just a minute. Huh? Can- Let me see the stamp report.
Yes.
Yes, record and order. Learned advocate for the appellant is present. Although although an application under section 5 of the Limitation Act is filed, but as for report of the stamp reporter, there is no defect. Thus, the appeal be placed before the Honorable Division Bench for the purpose of admission. The defects pointed out be removed in the meantime.
Scan one.
Yes, scan 1 of 2025 becomes impractical.
One of the appellant, so there is a no direction to say the amount to where the deposit by the respondent insurance company, Lordship.
Let me see. Who is for the other side? Let me see the record. There was a direction to make the payment.
Payment,
So it has to be deposited.
deposited where?
Yes, record and order. Learned advocate for the parties are present. The matter is put up for necessary clarification and modification by judgment dated December 19, 2025. There was a direction issued upon the respondent number 1, Bajaj Allianz General Insurance Company Limited, to deposit the balance amount of rupees 3,46,339 along with interest at the rate of 6% per annum from date of filing of the claim case till today. Stop. This direction is modified and it is directed that such amount be deposited before registrar circuit bench Jalpaiguri High Court Calcutta. Other contents of the order remain unaltered.
Chief Inspector, I am for the appellant. Speaks for judgment.
Yes, I'm reading out the operative portion. Thus, this appeal stands disposed. The judgment and award dated 31st August 2024, passed by the learned additional district judge, Fast Track First Court Jalpaiguri in MSC 604 of 2022, with regard to the principal amount is affirmed. However, the respondent number one, United India Insurance Company, is directed to pay interest on the principal amount awarded by the learned trial judge at the rate of 6% per annum from the date of filing of claim case till actual payment. Such deposit be made before the registered circuit bench, Jalpaiguri, High Court, Calcutta, within 5 weeks from the date of communication of this order. Next. Yes, hence this appeal is dismissed. The judgment and award dated 27th day of March 2024, passed by learned additional district judge, First Court Siliguri, Darjeeling in MSC number 63 of 2010 is affirmed. The respondent number 1 to C is 6 is permitted to withdraw the awarded sum along with interest as directed by the learned trial court and deposited by the appellant. It is however clarified that if the statutory amount of rupees 25,000 is deposited, apart from deposit of the awarded sum, the appellant will get back the statutory amount. Yes, emotional. Yes, yes. Okay, not this week, next circuit.
My lord, then they should not proceed with that.
Okay, just record an order. Learned advocates for the parties are present. Prayer for time is sought for by learned advocate for the opposite party. Stop. Let this matter appear to the next circuit. As the matter is sub judice before the scope, parties facing adjournment before the learned trial court which may be considered.
Please, my lords, I beg to appear, my lords, for the petitioner. My lords, this is a challenge against an order whereby, my lords, the learned trial court has allowed an amendment application filed by the plaintiff. I am
The question is, it is, the trial court has allowed the prayer for amendment.
Please, my lords.
Yes.
I am the
So-
defendant, my lords. The plaintiff filed the application after 7 years when the trial has begun, my lords.
Anyway, the matter has to be heard out, let it be placed before the next circuit.
My
Yes,
lords, in the
record an order.
meantime, my lords, in the meantime, they should not proceed because, my lords,
It is in the month of February.
Learned advocates for the parties are present. A prayer for time is made by the learned advocate for the caveator. Opposite party number, opposite party. The matter stands adjourned. Let it be placed before the next available circuit. Stop. As the matter is sub judice before this court, parties may seek for adjournment before the learned trial court, which may be considered.
grateful, my lords.
Fine, okay. Next circuit. Yes, what is the order?
Order dated 12/6/2019. Petition was for impounding of the insufficient stamp duty,
Yes.
but it is proceeded on the separate confirmation about unregistered, registration and unregistered agreement, and the petition is, however, rejected or informed.
This petition is rejected.
Yes,
It was your petition.
this might be,
So I guess that you have come.
yes.
Was the defendant before the trial
I'm
court?
defending.
Servant come? Yes, record an order. Learned advocate for the petitioner is present. Third learned advocate for the petitioner. Let notice be served upon the opposite party. And affidavit of service be filed. Let the matter appear before the next available circuit. As the matter is submitted before this court, petitioner may seek adjournment before the learned trial court, it may be considered. Yes, next circuit.
In a suit for declaration, the petitioner being the defendant number one took out an application for recalling of witnesses at the last stage of the witness being examined. That
Oh,
prayer,
you are for
defendant number one,
petitioner, defendant number one.
defendant number one, yes.
Yes, where is the order under challenge?
Last order, the order dated 29th of October 2025, order number 111. Last page. Certified copy. That's it. Order dated 29th of October.
Yes. is not allowed.
Yes, not allowed.
Yes, record and order. Learned advocate for the petitioner is present. Or learned advocate for the petitioner. Let notice be issued upon the opposite party and affidavit be subject be filed. Let the matter appear before the next available circuit. Stop. As the matter is sub judice before, as the matter is sub judice before this court, the petitioner may seek adjournment before the learned trial court, which may be considered. Just obtain adjournment.
Date of,
No, no, for that I've made it clear that as the matter is sub judice, you are permitted to take adjournment.
next available, sir.
Next available circuit. But you serve the copy and file affidavit of service.
Grateful.
Acha, call the MSCC matters admission. Application MSCC matter. MSCC, let me call this MSCC matter serially. 44 থেকে ডাকুন। 44, yes, not today.
45,
Not today,
43,
not today.
47,
Yes, 47. Okay, next, not today. 48. Yes, 40.
50,
Yes. You have served. Wait, can one? Can two is for? Can one? Can one is for stay? Yes, record and order. Learned advocate, you file your affidavit of service. Learned advocate for the appellant insurance company is present. The application for, none appears for the respondent in spite of service. The application for condonation of delay being canned of 2025 is taken up for consideration. Our learned advocate produce the petition file. Upon producing the petition and upon hearing the learned advocate, this court is of the view that the appellant has shown sufficient grounds for the delay. Thus, delay in filing this appeal is condoned and can 2 of 2025 stand. Can 2 of 2022 stands disposed. Stop. Can 1 of 2022 is taken up for consideration as the appellant insurance company has deposited the entire statutory amount. He has deposited the statutory amount of rupees 25,000. There shall be an ad interim order of stay of the judgment and award passed by the learned additional district judge. Additional district judge, special court, Jalpaiguri, for a period of 5 weeks from date. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial court within this period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, there shall be a stay of the judgment and award passed by the learned trial court till the disposal of this application. The appellant shall take further steps to call service of produce upon the respondents. Liberty to mention. Whatever it you serve, suppose you want any recovery from the owner, then you have to serve. Record an order. Who is for the other side, respondent? We are not. Okay, record an order. Yes, your name please. Mr. Hirok Bormon, learned advocate for the appellant. CI Lombard General Insurance Company Limited submits that his client is not interested to proceed with this appeal. Mr. Bormon has also filed the letter of instruction. Stop. In the facts and circumstances, this appeal stands disposed as withdrawn. Interim order, if any, stands vacated.
Lordship, one remains that seek liberty to withdraw the statutory deposit.
Okay. The statutory deposit, no, the interim order is vacated. The statutory deposit is made by the appellant insurance company may be released by the registered circuit bench, Jalpaiguri High Court, Calcutta, upon compliance of the necessary court. Yes, not today.
For the appellate entity.
So, what application is to be taken up? Can one?
Can one and two, filed by the insurance company.
Can one is what? Or stay or section 5? Section 5? Yes, they can. How many days delay? Yes, record an order. Learned advocates for the parties are present. The application for condonation of delay being CAN 1 of 2025 district number consideration. Part learned advocates peruse the petition file. Upon perusing the petition and hearing the learned advocates, the school is of the view that the grounds of delay is sufficient. Thus, delay is controlled. Stop. CAN 1 of 2025 stands exposed. Yes. But CAN 2 of 2025. Yes, CAN 2 stay. Have you deposited the statutory amount? Where is that document? If I condone the delay, you come tomorrow, find out the challan or whatever it is, so it has to be filed. You come tomorrow, okay? Okay, I'm recording your submission. Learned advocate for the appellant submits that the statutory amount is already deposited and the challan will be filed by tomorrow. Thus, the judgment and award, recorded to the judgment and award dated 18 December 2023, passed by the learned additional district judge, second court Siliguri Darjeeling, shall remain stayed for a period of 5 weeks. The appellant insurance company is directed to pay the entire awarded sum along with interest within the period of 5 weeks, excluding the statutory amount. Now, in the event the entire awarded sum along with interest is paid, is deposited, the ad interim order of stay shall continue till disposal of this application. Liberty to mention. This order, yes, please file.
Worship,
Let the challan be filed by tomorrow.
Worship, in item number 54,
Yes.
in this matter, I am submitting the paper with the honorable court and also handed over the same to the learned advocate for the insurance company.
Four. Yes, record an order. Learned advocate for the appellant is present. Let the paper book be filed. Paper book file be kept with the record. Liberty to mention.
Worship.
Yes, Worship, I want the appellant, Worship.
So on the last occasion, time was
Yes,
granted.
yes, Worship. Worship, my lord, also, my one matter already been disposed of, can, correction of.
Why last occasion time was granted, why you could not file it?
Worship, can, with objection can be disposed of, Worship.
Okay, let this matter appear before the next circuit. The respondent number one insurance company is granted liberty to file the affidavit in opposition on or before. Affidavit in opposition on or before 6/1/2025. Reply if any by 9/1/2025. Liberty to mention. 9/1/2026. Paper.
Worship, I am for the applicant. Other applicants, right, by insurance company, national insurance, and the other insurance company, oriented. Worship, all my kinds, the orders. that-
No, anyway, this application is to be heard out.
Worship, the appeal may be hard out.
Oh, question is appeal cannot be heard out within 1 or 2 days. If there is any urgent appeal,
Then Worship as you please.
you are for the insurance company.
But-
Okay, then not this week. Next circuit.
All time we are not turning up in each occasions.
So one of the insurance companies present.
No, they have already paid. The appeal filed by the insurance company, they are not appearing. National insurance, all time.
Record an order. Learned advocate for the appellant and learned advocate for respondent number. You are for respondent number one.
Where 20, where? In 5. Okay. 750. Experiment number 3.
Yes. And appears for, that means respondent number one has not appeared.
That's one, 2. National system.
Respondent, learned advocate for the appellate and learned advocate for the respondent number three is present. None appears for the respondent number two. Although the matter is appearing in the list for a long period. Stop. Is appearing in the list for a long period. Let this matter appear in the next available circuit. The learned advocate for the appellate is requested to intimate the learned advocate for respondent number two by notice. FMET 7. And let this matter appear along with FMET 50 of 2025. Yes.
And for the applicant matter, NBSTC.
Is for the claimant is here.
Claimant, this is my affidavit of service, madam.
No, can one is what, delay application?
Can one was allowed,
Then
can two is the stay application, which.
the deposit is being made.
Whose it is not paid, my lord.
Then how there can be stay? Neither statutory amount have you deposited.
I am the offending vehicle, my lord.
Yes, SCST is offending vehicle, but if you want a stay, you have to deposit rupees 25,000 at least. Thereafter, if you want a stay till the disposal of the appeal, you have to deposit the entire awarded sum. Anyway, you take instruction, you consult your learned friends who appear for the insurance companies, come tomorrow, or you can place it before the next circuit.
That will be.
Yes, next circuit. Yes, all 60. Yes.
It has not been solved from the respond.
Okay, our next circuit.
My lord, I am appearing on behalf of the appellant. My lord, there are only two grounds. First, my grievance is that the interest amount was not being granted.
Yes. Now, who is appearing? Anyway, other side is not here. You serving a copy, huh? Next circuit.
My lord, let me submit the paper book to the court.
Let you do it in the next circuit, okay? Yes.
Next circuit.
Item 23. Acha, item number 23. Have you served copy?
Service has been rejected because they have appeared on the last.
Acha, item 23 within first 5 matters tomorrow. Oh, you see, hearing matters is not possible, right? If you can bring the other side, I can consider tomorrow. Anyway, I shall see tomorrow. You can bring your other side. Acha, item 42 and 43 within first 10 matters. No, after taking the application matters, if time permits, okay, both sides are there. Tomorrow I shall take only urgent matters. And after taking the urgent matter, if time permits, if both sides are present, it is a very short matter. No, hearing matters, you see, is not a short matter.
Yes. Item number 20, the other side is also. Both the parties are trying to reach an amicable.
Acha, item 25 within first 10 matters. seeing the other side. If both agree, I shall see.
Item 82, if it is possible to.
82.
82,
82 for what? Hearing?
just for the insurance, interest, only one interest, only interest,
Okay. Tomorrow I
Your
shall-
Lordship, item number
After
38.
urgent matters, if type per-
only interest, madam. Just one matter.
আচ্ছা, কালকে একটু উপরের দিকে দিয়ে দেবেন তো এই 15টা আইটেমের মধ্যে ইউ গিভ দ্য স্লিপ 15টার মধ্যে ঢুকিয়ে দেন
Your Lordship, item 38.
ইয়েস
Your Lordship, item 38, Your Lordship. It's
Yes.
an, the state petition is pending, it's an ex parte hearing would be going on, Your Lordship.
ওকে ওকে টেল ইউ জুনিয়র টু গিভ দ্য স্লিপ
Yes, Your Lordship.
আজকের
Yes, sir.
activity নাম্বারটা দেব, আজকের আইটেম নাম্বারটা দিব। মানিতে থাকবে না?